July 20th, 2023. Rosalie, would you please take the roll call?
Chairman Loper,
Present.
Vice Chairperson, Member Ward, Member Cardin,
Present.
Member Clapp.
Here.
Chairman, we have a quorum.
Fantastic. Move on to the minutes for the May 18th, 2023 hearing. Are there any comments? Seeing none, those are considered approved. Move on to the announcements. 1, this meeting has been noticed in accordance with the open meeting law of ARS 38-431. 2, agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office, and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony in a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card if you're here in person, or registering your desire to comment as noted on the published agenda if you're doing this virtually. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. I failed to mention that if you do wish to speak and you're in attendance, you need to fill out a comment card, and Rosalie, who's got her hand up right there, she will hand that to you to complete prior to speaking. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for testimony shall be at the discretion of the chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. All votes will be done by roll call only, and the chair will verbally identify the specific board members responsible for all motions and second. With that, turn it over to staff for the consent agenda.
Good morning, Mr. Chairman, members of the board. There's one item on your consent agenda this morning. It is case BA 2023-029 for the Lindstad property, located in Supervisor District 2. And this is a request for a proposed hillside disturbance of 1,550 square feet outside of the lot's principal building envelope where it would otherwise be prohibited per county ordinance. The site is on assessor parcel number 219160220T at 13319 Blue Coyote Trail in the Fort McDowell area. There's no violations on the property and no known opposition. Staff recommends approval. Can I answer any questions?
Thank you very much. Are there any questions of staff from any board member? We have no speaker cards. Is there anyone in the audience that wishes to speak on this item? David, is there anyone online who wishes to speak? Seeing none, we'll go ahead and take roll call for, or we'll consider a motion and a second for the consent agenda.
I'd like to make a motion. I'd like to move to approve case BA 2023-029.
We have a motion for our approval by member Clapp. Is there a second?
Second.
Thank you, member Cardin, for a second. Rosalie, if you please take roll call.
Member Cardin,
Yes.
Member Clapp,
Yes.
Vice Chairperson, Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-0.
Consent agenda has been approved. Apologize, member Clapp, I didn't see your icon on the screen. Move on to the regular agenda. First item on the regular agenda is BA 2023-024. Staff, if you go forward with your presentation, please.
Thank you, Chairman and members of the board. BA 2023-024 is a request for varying the required separation distances of a marijuana facility from protected uses in Supervisor District 2. The subject parcel is Zone C3, located at 11343 East Apache Trail in the East West area. Request number 1 proposes a separation distance of 530 feet or 1,500 feet is required per the MCCO for distance separation from adult-oriented facility for a marijuana use. Next slide, please. Request number 2 proposes a 930-foot separation distance where 1,500 feet is required per the MCCO from a church and or other houses of worship from a marijuana use. Staff believes the request fails to meet statutory tests for variance approval as the only physical hardships proposed involve the location of protected uses within the required distance buffer and not with a peculiar condition related only to the subject parcel. If the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination in a motion to grant the relief sought. At this time, I would be happy to answer any questions you may have. Thank you.
Thank you, Andrew. Very thorough. Are there any questions of staff from any board member? All right, seeing none at this time, I'll go ahead and open the public hearing. The applicant or applicant's representative, please come forward.
Good morning. For the record, Mr. Chairman, members, my name is Larry Lazarus and Sylvan. My address is 206 East Virginia, Phoenix, Arizona. We represent Mr. Shiraz's work with SS3 investments in this case. There are people who are here in support, but I do not believe they wish to speak. Back of the room. Got the right slide up, thank you. As staff explained,
I cannot hear.
Just remember, no one's speaking at this time. They're working on getting the presentation operational.
Thank you.
Member Clapp, this is Member Cardin. This may be an issue on my side, but I wonder if, and maybe you are muting, but in between when we're not speaking, if you mute, I'm getting a little bit of feedback, and I'm wondering if that would help.
We should probably, including me, be on mute when we're not speaking. I have a tendency to leave mine on.
Just for the record, whatever changed, it is much, I don't hear any feedback anymore.
Sorry for the technical difficulties. Usually when this happens, we have Matt will do a hand puppet show, but he's not up to it today. So
sorry I missed that.
we're back on. Go ahead, Larry.
That's our second slide. Okay, thank you. As staff has explained, we are looking to open a marijuana dispensary at the location shown in red on that slide. As you can see, the area is all commercial along Apache Trail or State Highway 88, largely dominated by more intense commercial uses that are closer to light industrial type uses. We have auto repair facilities, tire stores, construction salvage yard, amongst others. With the highway frontage and the commercial corridor buffer, this site lends itself well to a dispensary from a planning perspective, as the use is insulated from any residential while still offering accessibility for patrons and employees. The site is also desirable, as initially our client was told the property met all of the separation requirements of the ordinance based upon two forms that were presented by the county staff. The first one signed in July of 2016, and the second on February of 2023, approximately 1 month prior to the pre-application meeting with the county on March 14th, 2023. And when our client at that time was told by the county staff that variances would be needed and would be required. Meanwhile, our client had already detrimentally relied upon the representations, the prior representations made on the forms already and had purchased the property in March of 2023. It wasn't until the pre-application meeting that our clients were told that variances would be required for a preschool and an adult use. When we got the case, we investigated and found that the school had been vacated and the church opened up a storefront location in Apache Shopping Center Plaza north of the Route 88, State Route 88. We contacted the property owner where the school was located and received a letter stating that the school has been abandoned, therefore eliminating the requirement for a variance, so the variance was withdrawn. Next slide, please. When the dust settled, staff concluded that 2 variances from the separation criteria were required. A variance from the adult use, as well as a variance from the place of worship that actually opened up after we had begun the permit application. Next slide, please. We believe that there are peculiar conditions in this case that meet the statutory and Maricopa County Zoning Ordinance tests and warrant the granting of the variances. We also believe that not granting these variants will cause an undue hardship for our client. The findings in the staff report state that there needs to be a peculiar condition related to the land. The state statute and the county zoning ordinance, as you can see on the slide, are essentially the same. The ordinance states that the Board of Adjustment may allow a variance from the terms of the ordinance if, owing to particular conditions, a strict interpretation would work an unnecessary hardship. And if in granting the variance, the general intent and purposes of the zoning ordinance will be preserved. There's nothing in the ordinance or indeed in the state statutes stating that there must be a peculiar condition only to the configuration of the property itself. Just a peculiar condition, which will work as an unnecessary hardship. It's not the same test that is required for cities and towns, and shown on the last box on this slide. The ordinance for cities and towns is more specific and states that the special circumstance must apply to the land, building, or use that do not apply to other properties in the district, including its size, shape, topography, and location of other surroundings. Next slide, please. Aside from our client's reliance on the forms, as I've indicated, signed by the county, in this case, we do have several peculiar or unusual conditions affecting the property that work as an unnecessary hardship. These conditions, according to the state statute and the county ordinance, may include how the surroundings create particular conditions to our property. And these conditions are: 1, as it relates to the church, there is a barrier in front of the, in the form of a divided highway that separates, that creates a separation, between our property and the storefront Living Word Spirit of Life of Fire Ministry Church across Highway 88 in the shopping center. Because of the divided nature of the highway, the distance actually one would need to travel to get to the church, to the dispensary, is approximately 2,640 feet. The divided Highway 88 does not allow access across it and creates a peculiar condition that affects the property such that it meets the separation intended by the ordinance. Secondly, as it relates to the separation from the adult use, Section 104 of the Maricopa County Zoning Ordinance addressing adult uses states in part, to prevent the concentration of adult-oriented facilities, which has been determined to be a cause to neighborhood deterioration and blight through an increase in crime and diminution of property values. This case has a peculiar condition in that the video store to our east is not really a nightclub or a bar or a place of gathering. It doesn't create a concentration or a gathering place for adult activity. This is a video store. It's much like a retail store. It does not create that congregation cluster of adult uses that would lead to the deterioration of a neighborhood. As a matter of fact, dispensaries have been shown to improve security in areas where they are located due to their enhanced security measures. As it relates to the Gentlemen's Club to our west, it's required to be 1,500 feet from the dispensary. It's actually 1,074 feet. This is over 1,000 feet across South Mountain Road, a major arterial, which also creates a barrier from our site. The purpose of the separation ordinance is to avoid clustering of adult uses. The location of this use certainly does not create a clustering of adult uses. This, again, is a peculiar condition, different than other properties in similar situations. Next slide, please. In addition to that, there is a hardship to the property in that the property is left with very little value for other uses. The property has been vacant for most of the last 10 years. In 2011, it was a Lucky 7 market. That market closed sometime before 2013, at which point it sat vacant for many years after that, until Manny's Tire Shop moved in 2018. Manny's closed and moved across the street in 21. It was then available for lease or sale, yet it remained vacant for 2 years before my client purchased the property. The use of this property is difficult. The location and small size of the property severely limits the potential uses of the property. The properties in this area are at least twice the size of this property that we're talking about today. And I do have a slide at the end of my presentation to show that. This creates a hardship. If the variance is not granted, there is not the potential for 100 uses on this property. Next slide, please. As you can see from this slide, this shows the historic vacancy factors related to this particular piece of property. Next slide, please. The variance test also meets the intent of the Maricopa County Zoning Ordinance. The variance meets the intent of MCZO by meeting the needs of the people requiring access to marijuana, including access to medical needs. The dispensary will create a safer, more secure condition than what has historically been on the property. Granting of the variances will not negatively impact the neighboring properties, the county residents, and meets the intent of the Maricopa County Zoning Ordinance, which is to promote the public health, peace, safety, comfort, convenience, and the general welfare of the citizens of Maricopa County. So in conclusion, next slide. Because of the conditions, we believe that there are peculiar conditions affecting the use of the property. 1. 2, that the surrounding land uses are compatible with this use and will not negatively impact surrounding properties. And 3, strict compliance with the ordinance creates an unnecessary hardship because of the investment made by our client by purchasing the property when he told that no variances would be requested. But more importantly, in addition, there are limited uses available to the property as evidenced by the history and vacancy on this property. I would like to reserve some time for rebuttal. And if there are issues related to the legal criteria that I was talking about, I would like the time to be able to address that. Thank you very much.
Thank you. Any questions by any board member of the applicant? Member Cardin?
Yes, thank you. Just, I think, a few questions. First of all, have there been, and thank you, Mr. Lazarus, for that presentation. Very helpful. Were there any discussions with the church?
Member Cardin, it's difficult to hear you, but the question as I heard it was, were there any discussions with the church?
No, there was not. That church opened up afterwards. It's a storefront church. We viewed some of the church congregation work, and church is closed quite a bit.
Okay. I'm sorry you can't hear me well. I'll try and fix that. But next question is, I haven't seen, other than the reference you made in your slide to the Gentlemen's Club, I'm not sure where that is. And it doesn't appear to be an issue because you're not asking for a variance from the Gentlemen's Club. Am I understanding that correctly?
We wanted to be very transparent in this process. It was not noted in the staff report. We did find that, but it is so far away. We did want to mention it in the presentation. Again,
okay.
Transparent.
So it is farther than 1,500 feet. Is that correct?
No, it is not. It is over 1,000 feet and across the major arterial, but it is not 1,500 feet.
Okay. And my final question, was the adult video store present and operating at the time of your client's purchase of this property?
Yes, my understanding was the adult video store was, the church was not, nor was the school.
Okay, thank you.
Thank you, Member Cardin. Any other questions of any board member at this time? All right, Mr. Lazarus, if you'll hang tight, may have some more questions for you coming up. As I mentioned, it's a public hearing. I'll get you in a second one. Is there anyone else in the audience who wishes to speak on this item? In favor or against? There is none, and we have no speaker request card. David, is there anyone online who's raised their hand that wishes to speak? Take that as a no. Okay. All right. No one's online who wishes to speak. Mr. Peck.
Thank you, Mr. Chairman. Mr. Lazarus raised two legal points, and as your legal advisor, I need to address those. The first being a detrimental reliance on what staff told them. Detrimental reliance, especially against the government, is a legal issue which is outside the purview of this board, so please do not consider that. If Mr. Lazarus were correct, there would have to be a suit. It would not be against the board, it would be against the county, and a judge would have to decide, so I ask you to set that aside. Second, as the staff report indicates, the peculiar condition, according to the Arizona Court of Appeals, as I discussed with you last month, I know the Vice Chairman wasn't here, must relate to the property itself, as the staff report says. Mr. Lazarus is 100% correct that the statute for municipalities is different, but the Court of Appeals interpreted the statute that relates to the counties and found that it must be to the land itself. So I just wanted to correct those two legal issues. Thank you. If any board member has a question.
Any question by any board member of Mr. Peck? I do have one, Wayne. If you can answer this, are you in agreement with the assertion that there is a hardship?
No,
As expressed, or you're just clarifying?
I was talking about peculiar conditions in the staff report, and he mentioned that to find a hardship, you have to find there's no available beneficial use of property. That was also out of the case that the Court of Appeals decided, and so you know, so I'm not springing anything on Larry. I gave him, I believe I sent him or gave him the site to that case the last time he was here.
All right, thank you. Seeing no one else wishing to speak at this time, go ahead and close the public hearing. And Mr. Lazarus, did you want to move for rebuttal?
May have given us a second. It's okay, we found it. It's all, no problem. Let me talk about that. It's important. I think we can have a slide as it relates to the case that we were talking about here. Yes. So one would believe that you can only obtain a variance only if there's a physical condition on the property. Well, the case that we're talking about is the case of JD's River Bottom versus Maricopa County. That case in itself, and that's the latest case dealing with peculiar condition. That case stated specifically, and I think it's on the second page, and we underlined it for your benefit. It stated that no Arizona cases define peculiar condition. What they did was they found some out-of-state cases, actually 2 of them in Alaska, that were that indicated in the late 70s and the early 80s that was their interpretation. And what they said was, in defining that they said that the physical condition of the property was a relevant part. But they also said that they were using this as a persuasive argument for this particular case under these facts. What the court found is that these were only persuasive findings, not precedent setting. As a matter of fact, the court went on to state, or stated in the first page, that the decision is not precedential. It does not create a precedent at this point in time. Therefore, the definition of peculiar condition is still up in the air in Arizona. What we're suggesting is, because of the difference between what the legislature absolutely stated in the 2 separate types of variances, it was clear that as cities and towns, that was the criteria, but it used different language when it came to counties. And we believe that the case law is still up in the air. There is no specific definition as stated by the Court of Appeals. And therefore, you have the right to make a decision based upon what you consider to be a peculiar condition related to this property, even if it's a peculiar condition that affects this property as it's allowed to be used. Thank you.
Thank you very much, Mr. Peck. A rebuttal to the rebuttal.
Not a rebuttal to the rebuttal. It's just giving you legal advice. If you were sitting in Pima County, Mr. Lazarus' arguments would be correct, that this case is not precedential. However, that case was decided against or for this particular board. The court has told this particular board that their standard is it has to relate to the property. So that we're transparent, last night, JD's filed a petition to the Supreme Court for review. But right now, there is a trial court case and a Court of Appeals case involving this particular board. And those courts have told you that your standard is it has to relate to the property. The Supreme Court may change that, but we're not there today. So while the case is not precedential, as a party to the case, you are bound by that decision.
Thank you for clarifying that. If you have a comment, you can keep it to 2 minutes. That's great.
It's going to be very short. I don't want to get into a legal debate up here in depth. The law that is being propounded is one that is statewide. And it does not define at this point in time, whether it's Maricopa County, Yuma, whatever county you're talking about. There is no designation at this point in time, specification as to what the absolute law is. The fact that this has been now appealed to the Supreme Court, it indicates even more that this is up in the air. So I'm not sure of the distinction between the various counties. Thank you.
Thank you. As I mentioned, the public hearing is closed. I'll turn it over for discussion and a possible motion by the board. This is in District 2. Member Cardin.
Chairman Loper, I just have a quick question for staff. The issue was raised of a gentleman's club within 1,500 feet. Is if this were going to be approved, would it need to also include? And I don't know. I'm just curious to have a good effect. Would it need to include a variance from the gentleman's club?
I believe it was that's inclusive of the variance, the smaller distance for the adult use. I'll turn it over to staff, but they have two adult uses, and the video place that's to the east. The closer of the two is the video place, and so the variance is for that particular distance. In other words, if it were granted, and I'm looking at staff to nod yay or nay, if it were granted, it gives them the 530 foot to an adult-oriented facility, which then obviously would then apply to the gentleman's club or any future one that came within 530 feet or greater. Did I explain that correctly? Hang on a second, Member Cardin. Staff's looking into that. I may not have explained that. Go ahead.
I just want to side comment. And if there's any confusion, we would also ask that we amend this to allow for not only the retail store, but also the gentleman's club at 1,500.
Mr. Chairman, if I may, variances are not granted to specific buildings. So I believe what should be done is you should entertain a request from Mr. Lazarus to amend the distance from, I think it was 530 feet to 1,100 feet, so he can encompass both of them at one time. Didn't he say it was 1,000?
You do it for
One is
both.
530, so
Right.
then it would mess up that one.
No, if you can allow, you can be not closer than 1,100 feet, 530 feet. I'm sorry.
Sorry, I'm like,
I'm
what's
sorry.
happening? What's happening?
Math is never my strong suit, member. Okay. If it says for the video store, just change it to any adult business and that would cover it.
And that's the way it's advertised. So
I
I think
don't do math.
Yes, Mr.
that's right.
Mr.
I think we're
Chairman,
good.
It says that. It says establishes minimum required separation distance of 530 feet from a parcel being used as an adult-oriented facility, et cetera, et cetera. So both of those would constitute an adult-oriented facility.
Thank you for the clarification. Member Cardin, that good? I saw the thumbs up. Okay. Is there any other questions or discussion from any of the board members? Again, it's in District 2. My only comment on this, I'll do this before somebody makes a motion, is I've been in planning a long time. When medical marijuana came out, there was quite the concern over its potential impacts on neighbors and commercial uses and everything. And that did not bear out. In my experience in regular marijuana is, like it or not, it is not seem to be a haven for illegal activities. I think the police reports or statistics that I've seen have borne that out, that there's no more significant crime at a marijuana sales place than there is at any other one. In fact, I think Mr. Lazarus spoke of this somewhat. Because they have security, there's probably even less. But I'll turn it back over to the board for further discussion and or motion.
Can you hear me?
We can now, yes, go ahead.
Okay, I had my hand up and I'm hoping I don't have, do you have the feedback that you had before?
We do not. We can't
Okay,
see,
great.
but we can hear you.
You can't see me, I can see myself.
Member Clapp.
Okay.
Oh, there you
There
are.
you go. There you go. Sorry, I've never used this go-to meeting app before. This is new to me. It's my opinion that we've created a hardship for the applicant by providing documents that led to the receiving a license from ADHS and purchasing the property and likely at a price that contemplated the county documents. The applicant relied on the decision of county representatives and their interpretation of regulations. In fact, specific language was added on the documents that the property had the proper zoning and separation requirements had been met. So the two documents were 7 years apart. And since no one is here to speak against the use, not even the church representatives, even though I would like to note that the church located in the areas was mentioned after the pre-app meeting on this case. So I agree with the applicant that granting a variance will not cause a negative impact on the neighborhood or on the general intent and purpose of the zoning ordinance, and I move to approve BA 2023024 11343 East Appaloosa Trail.
We have a motion for approval, as I understand it, from Member Clapp. Is there a second? We have a second for approval by Member Person. Rosalie, if you please take a roll call vote.
Member Cardin,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes,
Chairman, that's an approval by a vote of 4-0.
thank you. If those of you that were here for this, if you could go, you're welcome to go ahead and exit, or you can listen to the rest of this riveting conversation. But please exit the building because there's an attorney here, as you can already tell. And so we have business. We'll just take a little quick break here while everybody exits the building. Yeah. Wayne, do you need an ambulance? I saw the color drop.
Chairman Loper, I'm not hearing anything if something's going on.
For Cardin, it's free to operate. We're still waiting for my feed out to want me to.
I think we're good. Oh, he's on a call? Okay, go ahead. We'll give it another 30 seconds. He may be a bit, so we'll go ahead and move on to item number 3 on the regular agenda. the LeBaron and Mendez property, which is BA 2023-028. Staff?
Thank you, Chairman and members of the board. Agenda item number 3, subject to case BA 2023-028, is a variance request for a RU zone property located at 73 West Tacoma Drive, Peoria area. The variance request is for a proposed east side yard setback of 15 feet, where 30 is the minimum required. In order to allow for the expansion of the existing attached garage from 776 square feet to 1,254 square feet for a third vehicle. County has not received any opposition for this request. Staff notes there is alternatives available to the property that would fall under the RU43 zoning district regulations, such as developing the proposed expansion as a standalone detached one-car garage, which would be allowable per Maricopa County Zoning Ordinance Article 1106.2. Staff finds case BA 2023-028 fails to meet the statutory test for a variance, as the applicant has failed to demonstrate that the strict application of the Maricopa County Zoning Ordinance to the subject property has caused due to undue physical hardship that prevents the reasonable further development of the property. However, if the board finds the applicant has proven entitlement to the variance, then the board must state on the records that the basis for the determination with findings and conclusion in a motion to grant the request. At this time, I am happy to answer any questions. Thank you.
Thank you. Great presentation. Are there any questions by any board members of staff? Member Person.
If, since this lot is on 2 streets, it appears, if that street had been considered the front yard setback, what would it have been?
So the front yard setback is 40 feet. They are proposing for the east portion. So they are, so it would be 40 feet for the front yard, sorry.
Okay, thank you.
Any other questions of staff by any board members at this time? All right, seeing none, I'll go ahead and open the public hearing. Is the applicant or applicant's representative here? They are online. Go ahead.
David, can you unmute Crystal LeBaron?
Good morning. My nephew Tyler is here with me to help me answer any questions that we might arise this morning.
Thank you. Go ahead. Give your name for the record and then proceed.
Hi, my name is Crystal LeBaron.
And you can ask if I want to speak.
And go ahead with your presentation regarding your desire for the variance.
So I have my nephew Tyler here, and I was wondering if he could help me this morning.
Absolutely.
Hi, good morning. My name's Tyler. Was just coming in to request this this setback for as far as the zoning is concerned. This is something that my Aunt Crystal will be able to build should she set it back by a very minimal amount, and so we feel that that this isn't really posing any sort of crazy suggestion to attach this versus creating a very minimal setback from the primary residence and creating this single car garage.
Is that the end of your presentation?
Yes, sir.
Thank you very much. Are there any questions of the applicant by any of the board members?
Sorry, I asked the wrong, I pulled a Wayne and was like backwards in my math, so sorry. I meant to ask you, what would have the setback been on an internal side of the property that wasn't by the street?
So the garage is being proposed internally.
Oh,
Yeah,
okay,
it's on the east side.
okay.
I do have a follow-up question, Paula, or for other staff. If this were detached, what would the side yard setback be?
3 feet.
3 feet. All right, thank you. Turning back to the applicant, are there any other questions of the applicant at this time? Go ahead and stay online throughout this particular case involving you. We may have other questions for you. Is there anyone in the audience who wishes to speak on this item? I have no speaker request cards. Is there anyone online who wishes to speak? David, anybody?
Chairman, I think David's having issues with the audio, but we don't have anybody else registered to speak on this case.
Okay, thank you very much. Let me go ahead and close the public hearing. This is in District 4, which is my district. My comment on this, I won't be making the motion. I hope somebody else can on my thing, is that consistent with what I've said in the past, if a structure detached would not need the variance, I think it reasonable that it be attached. It has less impact on the neighboring property attached than it would if it potentially would if it was detached. I, for one, if it were me, I would want my additional garage next to the existing garages. I am personally in favor of this variance. With that, turn it over to the board for discussion and or a possible motion.
Chair Loper, I share your feelings, and I'm prepared to make a motion that we approve case BA 2023-02.
Thank you, Member Person. We have a motion for approval. We have a second.
Second.
From Member Cardin. Rosie, if you please conduct the roll call.
Member Cardin,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-0.
Congratulations to the applicant. Move on to the next item on the agenda, item number 4, which is BA 2023-032, the Parks property in District 3. Turn it over, Joel.
Chairman Loper, members of the board, agenda item number 4 is a variance request for an RU43 zone property located APN 211-21008D in the New River Desert Hills area in Supervisor District 3. As written in the staff report, approving this request would have the effect of allowing for a proposed lot width of 132 feet where 145 feet is minimum permitted to facilitate the construction of a single-family residence. Next slide, please. The subject parcel was created as a portion of a lot created by a minor land division in 2021. Subsequently, the lot was split into its current configuration upon the owner taking possession of the property in 2022. Next slide. The owner then applied for a building permit in 2023 to develop the residence. At that time, zoning plan review indicated a non-compliant lot width at the south front of the lot, thus causing the variance request for the property. Next slide. While the lot is 100% hillside with extreme downward sloping on the northwest of the lot towards what is an apparent arroyo, the proposed residence is located on the flatter eastern section, and the site design otherwise appears to be in compliance with all other aspects of the zoning ordinance. The topology itself is indistinct from neighboring lots and is typical of the New River area. Therefore, staff is recommending denial on BA 2023-032 for the following reasons. The applicant has failed to demonstrate that there is a peculiar condition facing the property because the existing hillside conditions are common to the surrounding area and not unique to the subject parcel and are not germane to the issue of the lot width. The issue was self-created in the line of title upon the unregulated land division, which created the lot. Finally, the applicant has failed to demonstrate that the strict application of the zoning ordinance to the applicant's property has caused undue physical hardship that prevents the development of the property, as there are alternatives available, such as lot redelineation, which would allow for the development of the property without variance. And at this time, I'm happy to answer any questions.
Thank you. Great presentation, Joel. Any questions of staff at this time by any of the board members? Member Person.
Thank you, Joel. You mentioned lot redelineation as a potential
He does not. I had a conversation with the applicant several weeks ago, and it is my understanding that currently those lots are undeveloped. So they're currently bare desert. It is understood that this is kind of an issue between these three lots, and that there is a possibility at this point, because there is no development, at least in staff's view, that such a lot redelineation is possible until such a development occurs.
Any other questions of staff? Any board members? I do have a follow-up to Member Person's question. In your estimation, would squaring off this lot by acquiring property, do you know if that would cause issues for the lots to the south, west?
These lots are pretty large as far as I'm aware. I forget how large the subject lot is, but certainly, we're talking 13 feet to get to 145 lot width. I would not see that as an issue if such land were able to be acquired.
Thank you. We'll go ahead and open the public hearing. Is the applicant or applicant's representative available? Come on up and provide your name and then tell us why you seek the variance.
Good morning. So my name is Andrew Parks. I'm the property owner of the property that we're talking about here. And, as Joel had mentioned, the variances for that furthest south line, which you can kind of see there, is 132 feet. And it goes north 60 feet, and then it opens up another 130. So the total lot width from east to west is 262. Then north and south, it's like 280, I believe. And so with, I'm trying to build a house for my family. I got 9 kids, and I'm just simply trying to build a home. As he had mentioned, I bought this lot last year, and the owner of the property to the south, he wanted to have an even 5 acres. And so that's how we kind of came up with our lot lines. And then in particular, there's the one shot that shows my grading and drainage with my house on there. And that one in particular, yes, right here, I had wanted the house to be in a particular location just because if you're looking to the west, you look down a valley and there's good views there. So with the placement of our living room, where we'd spend most of our time, we'd want to be looking out those windows to the west down the valley. And that's how we wound up with this. I did receive a letter from the property owner to the south stating that the variance for my lot won't affect anything with his lot. He has no objection to it. He sent it to me signed, and I believe I forwarded it off to Joel here. Yep, so you guys should have it. And so if I can get this variance, it'll just help move forward with our house build. Like he had mentioned, I did apply, or I submitted my application for building, I think in January. So we've been, going through certain little hoops, getting things checked off, and it's middle of July here. I do believe if we had to resurvey the lot, that would take an additional 6 months. And I don't know if the property owner to the south would necessarily be open to that, just because he wants to maintain his specific size. And like I had mentioned, the owner to the south there, he has no objection to the variance. He said it does not impact him in any way, and he was all for it. So that's all I have.
All right, thank you. Any questions of the applicant by any of the board members? Member Person.
I'm sorry, I cannot hear.
I'm sorry about that. Can you hear me now?
Yes.
Sorry, being lazy. I'm asking a question of Joel relative to the bigger parcel to the south that you can see on the screen just below the blue highlighted area. If someone were to come in with a request to build something on that lot because of that kind of flag part on the bottom left, would they have the same issue with the lot width?
I would have to measure that out, but as long as it's 145 feet, it'd be compliant. But not subject of the variance. I did not review that.
The reason I ask is because I was kind of calculating here, and if there were an opportunity to do a swap with this guy, like, hey, give me 12 extra feet, kind of in that notch, it would probably mean then taking 5 feet off the bottom line on there to get back to that 5 acres. And, sounds like there's a potential that he might be amenable to it, but I think that it would be interesting if you were also able to tell him, hey, you may run into this same issue. So while you're doing that, you might want to look at changing some other lines, because I think this other lot to the left of you is going to have the same problem too. So I don't know if that's a discussion you're willing to have.
Yeah. So I have talked to him about that, especially with that lower southeast section, explaining why I'm here today. And for the time being, he's just planning on sitting on the lot with future build. And so I know he'd probably have to come here and talk about it with you guys. I did kind of discuss adjusting, and he was like passively like, oh, okay, but it didn't sound like he was necessarily like, yep, let's do it. And so I don't know if I want to necessarily go back to him and say, well, in order for this to keep moving forward, I have to get this completed. And then I guess while I'm thinking about it here too, the question about the hardship, I believe I answered it because, as I completed the form and sent it in, talked to the guy who did my grading and drainage, and he explained like the hardship is, so far I have about $120,000 into this lot, and with the purchasing the lot, the survey, the grading and drainage, my house plans, engineering, etc. That variance isn't granted. I guess I would be out of that $120,000 trying to build a home for my family.
Thank you.
I do have a question. It looks from the aerial and from the site plan that there is a decently sized, that's a wash that kind of separates the western third of the property, not adding to your hardship, but it would seem that would preclude potentially building at or near it. I don't know what the grades are. This particular exhibit we're looking at doesn't really lend itself to that area of the north part of the property. Like Member Person trying to problem solve, thinking, oh, maybe you could shift the house northward. It looks like that probably couldn't, either for the home itself or the septic. I don't know if you investigated that at all.
Yeah, so when you look at it, so this image has like grading on it, but my septic would actually go off that northwest part of the house and head north. So then I start getting too close to that wash that you're talking about there.
I believe there are some separation requirements from washes. Thank you.
It's kind of like the ideal spot, I guess, to try to put my house with the septic and then capture it.
Thank you. Question of staff, not to confuse this anymore, but it looks like the property to the east and maybe further to the south is state land.
I believe so, yes.
So is this a section line along the eastern boundary or a midsection line, or do we know?
I don't believe it is. I believe I checked at the time. I don't believe it. Or midsection line.
If it was, that would be the front, no?
Well, it'd be the shorter of the two sides. So the south would still be as that goes there.
Potentially could be if it was a street. We don't know if there's a 33-foot dedication there.
I don't believe so, no.
Okay. All right. Any other questions of the applicant at this time? Seeing none, if you go ahead, just hang tight. We may have more questions of you. As I mentioned, this is a public hearing. I see no one in the audience wishing to speak. I don't have any speaker request cards. David, is there anyone online? Or Rachel?
Yeah, Chairman, we don't have anyone registered online.
Okay, and we did have, as mentioned, we did receive a letter of support from the property owner to the south. Thank you for supplying that to us. I'll go ahead and close the public hearing and turn it over to the board for discussion and or a motion. This is in District 3.
Thanks, Chairman Loper. I'm inclined to approve this while I suggested that perhaps the applicant could talk to the owner to the south. When I look at what I think would need to be done for the lot split or swap, I don't know that it could happen without impacting that hillside and the grading that's happening. So I'm going to make a motion that we approve case BA 2023-032, subject to the language of the property code.
We have a motion for approval by member Person. Is there a
Second.
We have a second by member Cardin. Rosalie, if you please take the roll call vote.
Member Cardin,
Yes.
Member Clapp,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-0.
Congratulations. Good luck with that family.
Thank you.
All right, we'll move on to the last item agenda, which is agenda item number 5, BA 2023-034, existing horse shed. I almost slipped badly there. In District 4, go ahead.
Chairman and members of the board, PA 2023-034 is a request to reduce the accessory structure setback requirement to 0 feet where 3 feet is required per MCZO Article 1106.2. Next slide, please. The subject property is approximately 2.5 acres in the rural 43 zoning district of Supervisor District 4 in the Whitman area. The subject of this variance request is a previously built horse shade structure, approximately 60 by 40 feet, which has been erected on the southern parcel boundary and is currently subject to an open violation. The shade structure has been standing for approximately 3 years. Next slide, please. The applicant has failed to demonstrate there is a peculiar condition relating to the property by not providing any evidence of an existing condition to warrant the variance request. Next slide, please. Should the board find the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. At this time, I would be happy to take any questions you would have. Thank you.
Thank you, Andrew. Good presentation. Are there any questions of staff at this time by any board member? Seeing the shaking of heads, no. Thank you very much. May have more for you. Oh, I do have one. Or two, actually. This came about as a violation case, but nobody responded in terms of opposition to the case, correct?
Correct.
And then do we know from the, and this is a question if the applicant's listening as well, they may know. Do we know the slope of the roof line? Is it sloping off property, on property?
Chairman Loper,
Okay.
it is sloping off the property to the property on the south. The higher portion of the roof is on the northern portion.
Kind of looked like that. Thank you very much. All right, this is a public hearing. I'll open the public hearing. Is the applicant or applicant's representative available to speak? I don't see anybody in the audience. Are they online? They are online, okay.
David, could you please unmute Al Gray?
I have Al unmuted. He should be able to speak. He needs to unmute on his GoToWebinar. There, looks like he's available now.
Yeah, I'm Al Gray. I'm representing Ron Giles for his property on this shade. This is an existing shade. It has been in place for over a couple of years. As stated, we are working to come into compliance with this shade. There's been no opposition from the neighbor on this shade, and ever since its existence. And from there, we've had a verbal communication with the neighbor who has no opposition to this shade at this time. But that's what we have. And I'm open to any questions on anything else in regards to the shade.
Thank you, Mr. Gray. Were there any questions of the applicant from any of the board members? All right. Member Clapp, did you raise your hand? You're muted.
Okay, I'm unmuted now. Is the property owner that is in support the one to the south where this roof is draining to?
Correct.
Okay, thank you.
Thank you. And just to confirm, the question by Member Clapp was, is the property owner to the south the one that's in support? And the answer was yes by the applicant. Any other questions of the applicant? All right, seeing none, there's no one in attendance here personally. We have no speaker request cards. Is there anyone online, David or Rachel, that wishes to speak on this case?
I do have Ron Giles online.
Mr. Giles, do you wish to speak?
He's muted on his side. He needs to unmute if he wants to speak.
I'm going to take that as a no. He did have, even though he's a property owner, did have Mr. Gray representing him. With that, unless Mr. Giles activates somehow, I'm going to go ahead and close the public hearing and turn it over to the board for discussion and for a motion. This is in District 4, which is my district. My comment on this changes, my thoughts on this change somewhat since the property owner of the south has expressed support for it. We don't know where the violation came from. Somebody clearly wasn't happy with it. There's lots of reasons that violations are turned in. I'm going to guess that it's not from the property owner of the south who has stated their support. I wish that people would check with the county before constructing these type of structures. This looks like it's fairly well constructed. I would imagine that it would be difficult, if not impossible, just to lift up and move. I am in support of it, but I'm looking for someone to make a motion. That over any other board members have any comments or wishing to make a motion? Member Cardin.
I move that we approve BA 2023034.
We have a motion for approval by Member Cardin. Is there a second? We have a second by Member Person. Rosalie, would you please take roll call?
Member Cardin?
Yes.
Member Clapp?
Yes.
Vice Chairperson?
Yes.
Chairman Loper?
Yes.
Chairman, that's an approval by a vote of 4-0.
Thank you. Congratulations to the applicant. That was the last item on our agenda, so we'll go ahead. Matt, did you have something you wanted to bring up?
Yeah, Mr. Chairman, just one quick note on other matters. The August 10th Board of Adjustment hearing has been canceled.
All right, we'll see everyone in September. Thank you very much. Everybody have a great day and stay cool.
Thank you.
Thank you.